Hello, everyone, and welcome back to the podcast. This is The Free Agent, where the discussion is all about free agency and taking control over your future. The mission of my show is to share inspiring conversations with real people who took the leap into self-employment, business ownership, franchising, and freedom. From corporate refugees and executives tired of the desk job to entrepreneurs and investors looking to share camaraderie and inspiration through their own business journey, the podcast aims a spotlight on real people who stepped into the unknown, took control of their destiny, and became their own boss. These are usually conversations that, for those of you who don't own a business, you wouldn't be hearing some of the topics that have been featured on this show. But I want you to know that if you are to become a free agent, what some of the experiences are that happened to us as business owners. And in the last year in particular, or 2008 to 11, there were a lot of ups and downs and navigating sneak attacks that we never saw coming. And yet a lot of us as business owners continue to produce some incredible outcomes. And today I am joined by Dave McClurg, who's a good friend and fellow networking member from my group, the First Friday group. And Dave is here not to talk specifically about free agency or self-employment, but as a corporate and employment litigator, Dave has brought an amazing amount of experience and resources that he shares freely with the group. And today we're going to talk about the state of business ownership here in 2021 in the first quarter. So Dave, thank you for joining me today.
My pleasure. Glad to be here with you.
It's always great to see you. We'll have another chance to do that later on this week. Rather than I talking about you and your career, why don't you tee up just a quick bio of who you are and some of the things that make you noteworthy, and then we'll move into the current state of business ownership.
Sure. Well, originally I started out my career years ago as primarily a personal injury attorney. Did a lot of work on fairly sophisticated products liability and automobile crash readiness cases. Required a lot of travel, deposing experts all over the country. After my daughter was born, the travel became a little bit problematic, and I switched my skill set, my trial skills, into the employment area now well over 20 years ago. It was a time after federal law had changed to allow employees the rights to trial in their discrimination, harassment cases like that. And many of the firms that had been handling those cases didn't have attorneys that were experienced in jury trial work like that. So I found a home in a boutique firm that did just labor and employment law, and was able to transfer my litigation skills, pick up a new set of substantive skills in the employment area, and have been doing that ever since, as well as some related commercial litigation. Perhaps one of the most interesting and noteworthy cases I've handled just a couple of years ago involved a disability discrimination claim in which one of my clients had an employee who was off on FMLA leave for 3 months with back problems. At the end of that period, he and a doctor decided he needed back surgery, and he requested another 2 to 3 months leave. The employer couldn't afford to keep his position open that much longer, terminated his employment, told him to return when he had his restrictions set, and they would try and find something for him. Instead, he sued and said, "You should have provided me the additional 2 to 3 months leave as a reasonable accommodation under the ADA, Americans with Disabilities Act." We disputed that and wanted every level from the federal district court in Milwaukee up through the Seventh Circuit Court of Appeals in Chicago, where I argued before a 3-judge panel. And then the case ultimately went up to the U.S. Supreme Court and was essentially rejected. And the win at the Seventh Circuit was allowed to stand. So that was a case that got quite a bit of publicity all around the country.
Yeah.
So those are the kinds of cases I work on: disability discrimination, primarily on the employer side. So I'm a management side labor and employment attorney, and I handle that type of cases, wage and hour cases, discrimination, that type of thing.
So I've got to imagine, based on everything that has happened here, not only the pandemic, but over the last few years and some of the changes in our political climate and our media as well, that the platform where you're operating has gotten to be more contentious and that employers are at greater risk.
Yes, I think that's true. Certainly, it's been confounded by the economic distress we've been under with the pandemic, because oftentimes when people get terminated or laid off is when they talk to attorneys and try and look for ways that they can hold their employer responsible for their discharge. So while in many cases the employees are going to be eligible for unemployment, they are perhaps seeking more and feeling that they were targeted for the termination or for the layoff because of their race or because of their sex or their age, and bring claims in those situations. So in periods where there is increased number of layoffs, you often see more claims of that type arising, and we have seen that.
And so for people who are listening to this podcast, they're business owners already, or they're contemplating that. What kind of confidence should they have, say, in working with you, that they will be covered, but with your expertise? I'm not sure I'm asking it very well, but.
Well, let me put it this way. Even though I view myself as a litigator, I also spend a great deal of my time counseling employers on avoiding litigation, because litigation is costly and they, of course, want to avoid it. That comes in the form of helping them develop policies that will help avoid those kinds of claims. It comes in terms of helping them in how to apply their disciplinary policy in an appropriate way so that they document issues that have come up. Often the biggest problem that employers face in these discrimination cases, when there's perhaps been a termination, is that they have not properly documented all the incidents that led up to the final decision. And so they say, well, this was the straw that broke the camel's back. Well, let me see all the other straws. Well, we didn't write that down. We didn't give the written warnings. We didn't give a suspension. It just came to a point where we felt we couldn't move on with this employee. So I try and help my clients understand the importance of documenting all aspects of the disciplinary process, including the counseling, the warnings, and sometimes a suspension is appropriate as discipline before a final decision on termination, to give the employee the chance to improve their behavior or their performance.
An ounce of prevention is worth a pound of cure, in other words.
Absolutely. And for new employers, I've got a whole seminar that I do. It's a half-day kind of seminar on employment law from A to Z, taking from issues regarding their very first offers of employment, through the disciplinary process, through the laws relating to discrimination that they might not be aware of. One interesting anecdote applies to the very, very first things that a lot of new employers do is posting a position for employment. And many new employers are not aware that Wisconsin law prohibits discrimination on the basis of conviction record. You can only screen someone out based on their conviction record if the circumstances of the crime are substantially related to the circumstances of the job. So, for instance, someone who had a conviction of child molestation certainly would be screened out of a position at a daycare center. It gets a lot harder to determine that relationship if, say, someone had a conviction 7 years ago for selling drugs, and now they want a position on a second shift in a manufacturing facility. And sometimes the employer will think, well, this is an opportunity for them to violate and sell in that circumstance. But you have to evaluate that very carefully, what the amount of supervision is. And that's one of the areas where I can help them avoid that. But getting back to this issue of the first thing that employers do in posting their job, it is against the law in Wisconsin to indicate in a posting like that you might intend to discriminate on one of the bases protected under Wisconsin law. So I've had employers who post something to the effect, they go through the job description and say, you must have a clean criminal record. Well, it just so happens that there is a gentleman out in New York who was a felon, ex-felon, and a paralegal, and he scours these postings, these online postings, for just that type of indication. And one of my clients got nabbed by this and made that mistake, put that on, and drew a claim of discrimination before the Equal Rights Division. As I looked into it and talked to people at the ERD, they said, "Oh, yeah, this guy will usually settle for, a few $1,000s." And I said, "What do you mean usually?" Well, I got his record. He had filed over 300 of these claims against Wisconsin employers. And my client said, "No, we are not going to abide by this. We did nothing wrong. This guy wasn't even going to come from New York and work out here." So we disputed it, and he backed down and went away. But I believe he's still out there looking for those things. So that's the kind of thing that new employers would not be aware of, that I can help them avoid that kind of pitfall and others.
Very interesting. And there are lots of stories, of course, about people who are in the legal field who are scouring for low-hanging fruit, easy targets. And that's a really interesting story right there about just case in point, that there are easy ways for us as employers to be ignorant about state law, federal law, and in something as simple as a posting. How often do you have your seminars, and when do you recommend that a business owner, for example, people who are listening to this and have not yet made their decision, when should they engage in that conversation with you?
Well, with new employees, I think it's important to go through a version of that, even if I don't do the full seminar for them. For instance, one of the members of our group that you host contacted me just a couple of weeks ago and said, "I'm going to be, making my first offer soon. I'm hiring my first employee. What do I need to know?" And we spent about 2 hours on the phone and going through a lot of the stuff. And, because of our relationship from your group, I did not charge him for that time, but I think now he will become a client for some other matters going forward. But I haven't given that particular seminar now for a couple of years, and kind of COVID thing has gotten in the way. I used to do those in person with PowerPoints and like everybody used to do. But I've just been recently considering trying to market that as a seminar for new business owners and doing it online and doing that type of thing. My firm has had some success in doing that in other practice areas, and so I think I may try and market that in the near future.
I would think that employment law, business law, with the way that things change, it's like updating your will. It's something that should be addressed on a regular basis. Your passport, get a new picture taken for your LinkedIn profile, and then go talk to Dave about what's happening in the world of world of business law.
Check your employee handbook, and because some things that used to be acceptable are now viewed as problematic. So, and the other thing is, we've got so many new laws that have been passed recently in light of the COVID situation that employers really need to take heed of and are going to be interested in. For instance, at the state level, the state legislature recently passed a law providing a liability shield for employers protecting them from most claims by individuals who might have suffered some illness or injury or damage as a result of COVID. So there was a lot of concern that employees or customers or people that your employees came in contact might claim they contracted COVID from one of your employees or in your place of business and might sue you directly for that. This law that was passed in Wisconsin now protects against claims of that kind that assert they contracted COVID as a result of your business's negligence or carelessness. It does not apply to claims of intentional or reckless or wanton conduct. So there's kind of a level at which a claim could be made that you essentially intentionally tried to infect people, or you so recklessly, knowingly allowed someone to come in contact with a group of people you knew to be infected, for instance. Yeah. But by and large, most of these claims are not going to be protected by that shield. The other thing that has recently happened is at the federal level, the American Rescue Plan Act was the big Biden program to do a number of things that affect employers. The extension of the payroll protection plan is one of those. A lot more money has gone into that, and they've just recently extended, I think earlier today or yesterday, extended the deadline for applying for that to May 31st. So there's a lot of opportunities there, but a bunch of other things in this act, and I'll just kind of briefly touch on them.
Yeah, please do.
There's a subsidy now for COBRA premiums. So people that have lost their job can extend their insurance coverage from April 1st of 21 to September 30th of 21 at no cost to them. Usually on COBRA, you have to pay the full amount as the employee. The employer, not only the employee portion of the premium, but the employer part. So you're paying the full amount. It's a big burden for someone who's lost their job. This provides a subsidy to cover those payments that is reimbursed to the employer or the insurance company running the group through tax credits. So that's a big thing for people that have lost their jobs. There is an extension for the tax credits available to employers who now voluntarily provide leave under either the Emergency Family Leave Act or the Emergency Paid Leave Act. Those were two programs started last year under the Families First Act, and we heard a lot about that back at the time. There's like 5 different reasons that people could, or employers at that time were required to provide paid leave. The required aspect of that ended on December 31st of 20, but going forward and now extended through September, I want to say September 30th of 21, yeah. Employers can still get tax credits if they voluntarily provide this emergency paid leave or emergency family leave to employees for one of these accepted reasons. And a big change was that they've now added to the original reasons that allowed it time taken off to obtain vaccination or for COVID testing or for side effects that result from the vaccination. Yeah. I know some people who have unfortunately not felt well after particularly the second vaccination. So this Leave Act allows paid leave for that, which the employer can then recoup in the form of a tax credit if they do this properly. The one thing they have to remember is that employers can't discriminate on the basis of the class of employee. So you can't say, okay, we're going to do this for our high-paid executives, but not the line workers. You have to provide it, the leave universally to all your employees, both full-time and part-time. And that might discourage some employers from providing that, because you do have to provide it for everybody or no one in order to
It's
get
so
it.
complex. And just as an employer, my husband and I have a number of companies, and we've got employees in a number of these under our umbrella. It is not only complex, but I also see, and maybe you do too, the unintended consequences of some of these programs and the disruption in revenue, the disruption in customer service, and other side effects
And
of
we'll
these.
get to that in the extension of the added unemployment benefits. There was some concern that the larger unemployment benefits that were granted back under the CARES Act and the Family First Act dissuaded people from returning to work because they were making more in unemployment than they had made when they were working. And that is one of those unintended consequences. But before I get off the Emergency Paid Leave and Family Leave Act, I should note that this new American Rescue Plan expanded the amount of benefits that are available under those from a maximum of $10,000 to $12,000, and it's allowing additional emergency paid leave to be taken even starting on April 1st through September 30th, even if they have used up their allotment previously of emergency paid leave. So there's kind of a whole new enrollment period, as it were, for these paid leave provisions. So they're voluntary now, no longer required. On the unemployment area, employees are now going to be able to get an additional $300 on top of their the normal unemployment benefits they are allowed under state law. And that is going to continue again now through September 6th of 2021. So it's for those people who've been on long-term unemployment, it's going to give them some more time to try and get their footing under them and find some new employment. So that's a major area. Another thing that is brought up under this American Rescue Act is subsidies for the Affordable Care Act premiums. So right now there is a limit on who can obtain subsidies to help pay for the premiums under the Affordable Care Act for the health care that's provided there. And that was limited to people whose income was below 400% of the federal poverty level. That cap on income has now been removed for 2 years. So essentially, at any income level, people can still potentially get subsidies under the Affordable Care Act. And it limits the total amount that households would be required to pay for their health care to 8.5% of their household income, so that some lower income families will be able to get this Affordable Care Act free, and will probably expand the use of the Affordable Care Act for at least for the next 2 years while these changes apply.
So for your employer clients, your clients who are employers, how much of this are they paying attention to, and staying on top of? How do they stay on top of all these new programs? And
these changes have been getting a fair amount of publicity, and some of my clients are very much aware, particularly of the payroll protection plan. That's the area that I think has garnered the most attention, because employers have potentially been able to get interest-free loans to keep their businesses going. In some cases, those loans can even be forgiven. So it is viewed as an opportunity in some cases for free money from the government to help their businesses survive the economic downturn.
Yeah.
So that's an area that most of my clients are very familiar with. These other changes that have just come up here, less so. Some clients just have not considered the practicality or advisability of offering this additional paid leave, even though they can get tax credits for it.
Yeah, yeah.
It seems like to them maybe it's going to involve too much paperwork, and why should they get involved in that? But it may allow their employees an opportunity to maintain and be able to come back to that same employer. So it may be a retention tool for the employers to provide this type of paid leave that the employers can get tax credits for.
It's really important as an employer to understand how well educated your employees are about the programs that are available to them. And there is that balancing act. It's to your point, in many cases, much better to embrace and offer and deal with the 29-page legal document that goes along with it that's convoluted and complex, but it's better to go that route than to have, say, a whole business full of unhappy employees who know that these programs are out there and talk amongst themselves, and you get yourself into hot water with by not offering your employees something that they feel they should be entitled to.
And one other thing that I do regularly is send out monthly labor and employment updates. And these issues we've been talking about under the American Rescue Plan Act will be in my next update going out within the next week, because this has just now developed since this plan was passed in March, and trying to unwrap some of the details of these issues that should be of interest to my employer clients.
Yeah, and just as an employer, I have to say that over the last 12 months, more or less, our employees in our different businesses have been happy to come to work and know that they're coming into a safe work environment and taking all the proactive steps that are necessary. It will get better. It will get easier. I think we still have another 6 months. Just to your point, the dates that you were reading off there, looking into September, that's another 6 months of programming and maybe uncertainty about employees coming back to work. Are you seeing your clientele express more or less concern about generating revenue and profitability? That's the bottom line, is profitability with some of these employment shifts?
Well, absolutely. And the question for many of them becomes, how quickly do we bring people back into the workplace, and how do we do it safely? And can we improve productivity and profitability by doing that? Or, maybe people can work successfully and productively from home, and maybe we can reduce our expenses by encouraging remote work sites. So there are certainly some employers who are now, having been forced into this experiment, are finding that, hey, this works out, and maybe we can work with and revise this model, provide people with the resources they need to work comfortably at home. I personally have been working primarily at home since the pandemic began. The firm was kind enough to give me a nice new laptop and a second screen. So I've got my two screens here, and much of my work is done on the phone and by email. And by and large, I've been able to continue on fairly productively here at home. My office is now reopening, and I may start going back in a few days a week, but I've kind of enjoyed working at home.
I know. I was just going to ask you, how do you, Dave, feel about this work from home coming to an end? And will you be afforded the opportunity to remain hybrid or make your own decision? It's got to impact your ability to litigate. But so how do you feel about all this?
Well, and I haven't had any major litigation cases that have been coming up for trial or hearing in this period. Yeah. I do have some coming up now, so I plan in the near future on returning to the office like maybe 3 days a week. In my case, it is up to my discretion how much and when I want to return. Not all employees will have that option.
Yeah.
Another issue that is coming up in this time when businesses are reopening is, should businesses make vaccination mandatory among their employees to make their workplace safer for all their employees. And that is a whole nother area that has to be considered very carefully. In fact, I think that was subject of my last monthly employee update, was the concerns about that. And I think most employers are going to encourage and incentivize their employees to get vaccinated. But I don't think that a lot of employers are going to make it mandatory, because there are potential problems with that. You have to accommodate people's medical situations, their religious beliefs, and you can inadvertently create liability that might not otherwise be there. So, but I think incentivizing, and one of the keys there is you have to be careful about, if you just offer a monetary bonus or some other prize for getting vaccinated, you can't ignore the people that choose not to be vaccinated. So one thing that employers in that situation have been doing is they might offer a monetary bonus for people that get vaccinated, but then offer the same bonus for people who choose not to be vaccinated to go through safety training on how they can safely return to the workplace or accommodate the fact that they have chosen not to be vaccinated. So you're treating them equally in that respect.
It's so interesting. Now, you've made reference to your newsletter. Does that only go to your clients, or can others get access
Others
to that?
can get on it. I have a email blast list that I regularly add members of my networking community to. I probably don't do it as religiously as I should, but anyone that wants to get on it, I'm happy to put them.
Well, and since we're coming up on the 30-minute mark anyway, why don't you go ahead and give people your contact information, so that if they would like to talk to you about some of the legal matters or sign up for your newsletter, how can people contact you?
I'm always available by phone. My cell is 414-559-7704. That's 414-559-7704.
And people should make reference that they heard about you via the Free Agent podcast, so that if they call or leave a text, that you have a point of reference. So make sure that they put in the Free Agent. I heard you on the Free Agent with Meg Schmitz.
That would be great if people could add to any message they might leave me, or that they heard about this through the Free Agent podcast. And my email address is dmcclurg, DMCCLURG, as in George, at PetriePettit, PetriePettit.com. So dmcclurg at PetriePettit.com. Again, note that you might have heard about this through the Free Agent podcast.
Well, so the topic is a little bit dry and intense, but for employers, you, and particularly our First Friday group, you've been an absolute godsend and a lifesaver, just adding your tidbits of wisdom to the conversation points as they have arisen. So thank you, as always, for your time and volunteering your expertise. People get afraid of becoming employers because of the legal matters, but there are great guys like Dave out there, and you've just been such a phenomenal resource for the group. So thank you for participating. It's been really meaningful, Dave. You're very important to me and my group.